Please, madam. This is notice in disguise of an order only. Demolition notice was served to me on, there are 4 petitioners before my lords. One was served on 3rd and rest 3 were served on 4th of May. The notice was this wise that if my lords may come to page 14, annexure A. May I read, my lordship, please? ઉપરોક્ત વિષયના અનુસંધાને જાણો કે આપના દ્વારા મોજે સુલપડ બરકમોડાથી માનવ વિમાન મંદિર સુધી હનુમાન મંદિરને જોડતા માર્ગ ઉપર નગરપાલિકાની કોઈ પણ પરવાનગી વગર અનધિકૃત ધીસ વેરી ઇમ્પોર્ટન્ટ રીતે રસ્તો પૈકી રસ્તો માર્જિનની જગ્યામાં ડીપી રોડની એલાઇનમેન્ટમાં બાંધકામ કરેલ છે, જેના કારણે રસ્તાને અડીને અનધિકૃત બાંધકામ હોવાથી જાહેર રસ્તા ઉપર પાર્કિંગ થવાથી વાહનની અવર જવર અડચણ રૂપે છે અને તેના કારણે દૈનિક ટ્રાફિકની સમસ્યા રહે છે, જેથી નગરપાલિકા દ્વારા 18/4/2023 ના રોજ સદરહુ અનધિકૃત બાંધકામના સ્થળે અનધિકૃત બાંધકામ દૂર કરવા અંગે માર્કિંગ કરેલ છે, જેથી આપને દિન 10 માં આપના ખર્ચ અને જોખમે સદર રસ્તા પર નગરપાલિકા દ્વારા કરેલ માર્કિંગ મુજબ અનધિકૃત બાંધકામ દૂર કરવા જણાવવાનું છે. જો તેમ કરવામાં નહીં આવે તો અત્રે નિયમ અનુસાર કાયદેસરની કાર્યવાહી કરી અનધિકૃત બાંધકામ આપના ખર્ચે અને જોખમે દૂર કરવામાં આવશે તેની જાણ. સર, now it is this wise. There are 3 things which I am before my lords. First, I am not an illegal encroacher.
Show me.
Lordship, please. Second thing, that this notice or this notice by the Nagarpalika states that there is a construction which is coming in the margin, and because there is a parking difficulty, traffic difficulty, therefore my structure must be demolished. My submission is this wise. This notice, if my lords may see to whom it is given, they have come with total 70 notice in hand. They have literally asked that this infrastructure belongs to whom, and his name is written on the spot through the second, no details of land, which survey number, what property, what is the infrastructure. Third, details of the property as if there is 100 foot of construction, 10 foot or 20 foot or 30 foot, how much is unauthorized, that is also not there. Now fourth, each and every petitioner, today I am with 4 petitioners. They were served on 3rd and 4th, and they are stating that in 10 days they will straight away demolish. No provision of law by what section they are following this activity, that is not specified. Now I am stating this wise that I may be heard once, my representation must be heard, post that my structure must be demolished. Therefore we have made representation to Nagarpalika on 12th. It was never heard. That is not, I will show the received copy. I have it with me.
You have not annexed it.
No, it was not annexed because initially when the notice was received and when clients came to me, I came before my lords, before the coordinate bench. Then I was not permitted. Therefore, I went to collector and made a representation under 258 as well as to Nagarpalika. I have received copy of both the authorities where my representation is pending. Now, apart from that, if my lords may come to page 2, next page, that is page 15, annexure B of first seal application. That is the 7 abstract 12. That is form number 7. Now here my lords, 4th person from the top, Chandubhai Maniyabhai. That is mine. So I am the petitioner. My name is Rakesh Bhai. I am son of Chandubhai, and on the 3rd page, that is page 16. I have given my caste certificate whereby it is stated that I am Rakesh Chandulal Patel, son of Chandulal Patel. Every property I have annexed the document. Hereby I am stating that I am on my survey number, not on any Nagarpalika's street or on anybody else's land. I am not even an encroacher. Straight away they are saying that they are not even stating that I am an encroacher. They are saying it's unauthorized, and because it is unauthorized and there is a parking difficulty, we want to demolish my infrastructure. Now lordships may permit that, if my lord may permit, there are judgments to that effect, that even if there is a case when it's an illegal construction, then at least an opportunity of hearing must be given to. Straight away demolition should.
Besides this notice, no other notice has been.
No other. This is the first notice. And one more thing, that they are stating that on 18/4/2023 they have come and marked it. Now, we post their marking as per 150 municipality. 1 month has to be given to me. 1 month. That on third, that is say 16th or 17th day, they gave the notice that now we are demolishing in 10 days. And one more thing, this is a notice where they are not stating me that now you show cause that why I should not demolish. They are straight away saying that 10 divas the under it will be demolished. Now lordships may permit me this, right? Any notice, at least the details of the property, page 9, lordships, page 9.
Yes, yes. that-
Yes. The
Okay,
details of
their notice is.
absolutely vague notice in my respectful submission. Details of my property, and second thing, they will come to demolish. They will start demolishing the infrastructure in such a way that suppose 10% or 10 lordship. Lord, I may
You
just
will not demolish it like that.
no, no.
The
It's a,
thing
it has
that you
already-
have come before this court, you should have at least brought one document showing your permission, that I am a legal person.
Yeah,
Where is it?
the demolition has already begun. I'm with the photographs, but there are total 70.
They have asked
houses.
you, 10 દિવસની અંદર જો તમારું ગેરકાયદેસર હોય તો દૂર કરો.
Miles, my
You're
infrastructure.
saying you're legal.
Yes, absolutely.
Where is it?
My Sadbar is there where
Satpar.
the Sadbar, my name is reflected. I'm on
Yes.
my land.
So if your name, but how much have you constructed on your land? Whether the
It's a
permission was
agriculture-
granted?
Lots. It's an
How,
agriculture.
how are you coming?
Then if another, all the petitions I may show, if petition number 2, serial number 2 petition is taken, the form number 8 reflects that on that Sadbar Rethan. My house is there from 50
Rethan,
years.
can you construct Rethan on the margin place? Can you
No.
construct Rethan on the road?
No, no, no.
No,
No,
correct?
not all.
Then you have to show
Hmm.
that you are in a legal construction. You have taken the necessary permission. You have your Rajachiti. Where is your map? Where is your layout plan? Besides this, I have not constructed.
There is no
Another one
permission.
that given me permission to construct on this. Nothing, absolutely nothing.
There is no permission for construction. I am stating it.
Then there is no permission,
No,
which
I
means you
have,
are illegal.
no, I am unauthorized construction. It can be rectified and it can be regularized. But what I am stating before my lords is this: is that
You
there is a
go
division.
before-
I'm sorry.
You go before they will listen to you and they will.
No, they have already started demolition. I may show it. No, they have already started. There is communication to police on 15th. On 15th also I have made a representation. Then post that on 18th they have started. Lordships may just peruse. Now lordships may just say only, I may just produce judgment of this honorable court stating that even if it's an illegal construction or division bench of this court.
It's not a single document of yours.
No, but even if my submission is this way, even if my construction is not legal, I must be heard once. Straight away demolition to
But
my
when you are
construction.
coming, you should show that this is my construction. Where is, you show me a single document which shows that this is your construction. There's
That is,
nothing. Satbar,
so
you are
my-
depending on the Satbar.
I am on my land therefore. And that construction is standing on my land.
Satbar, there are how many names?
There are 4 to 5 names.
Yes. Which side of the plot are you on? East, west, north, south? Whether you are on the road?
For that also, they have to, for that specification also.
You coming, they will later on, they later. You
for
are
that
coming
spec-
with a specific case.
Yes.
I expect you to come with proper documents.
I may submit it this way. My construct, I may produce the.
Where is your construction? Show me your construction on this. Come on. All 4 cases, show me your construction.
It's a property which is, it's a construction.
Where?
50 years old. There's petition, the other petition where my light bill is there, house tax is there, whereby I am paying taxes from last 30-40 years for all these constructions. And there is light bill also. And house tax receipt. I'm sorry.
खेती लायक उपयोग.
Lordship, but usually what happens is that they construct
वलसाड,
a,
वापी शहर.
they construct a house, they stay there and they do the agriculture activity in the remaining end. And originally it was not even the road by the Palika. It was originally a road which was for Gala, but then it extended and my land which was far inside came on the road. One more submission, if my lords may see the judgment, that shows that this judgment and one more judgment, it shows that, you know, even if my construction, they have to specify what area.
You show me your construction, then I can look into the construction. You are not coming, you are coming with a Satbar.
Lordship.
Yes, which shows खेती लायक जमीन. Now you are saying I have made construction on that. What is the construction? Where is the construction?
I have stated
How do I give a blanket protection to you?
because I have stated in the petition that my house and my shop on the ground floor
And shops
shop on the
in
ground.
30 lakh zameen without permission.
Lordships, me just for a moment.
Shop.
Shop.
Now you're coming to shops.
No. There are yes, there are
You
shops.
are staying there and making.
Yes, there are shops, but the shops are this size.
Behind.
I was staying in that same house only. I went on the first floor and ground floor shops are constructed.
Yes.
Therefore-
Now you are saying without permission.
It's stated in the petition that I have I have shops also on the ground floor and first floor I am residing. It is in, I may show.
You go before the Nagarpalika and the Nagarpalika.
I have gone. That's what I'm saying.
Yes, so we will pass the order that you go before. Get the
But the
Nagarpalika.
Lordships may just see from once
And
we-
decide in accordance with the.
the Lordships may just consider this wise that my photographs which are already stating that there is demolition which has already begun.
So we will pass an order accordingly, let the Nagarpalika
But
listen.
then Lordships may
And then-
permit me to furnish the judgment that are protecting me and my rights.
Furnish,
Lordship,
yes.
please. So this judgment which I have given the page 9 of the page 9, page 10. I'm sorry, page 10 of that judgment. Para 15. Lordship, may I read?
Hmm.
Appellant furthermore acted arbitrarily insofar as he demolished the structure. Despite pendency of the suit, we would assume that the order of injunction was granted for a limited period, but it is expected of a statutory corporation to act thereupon upon informing the court thereabout. Furthermore, the notice was vague. It did not contain any description of the property. How much area of the property was the subject matter of unauthorized construction has not been disclosed. It is not in dispute that a plan for construction of the building was sanctioned. It was therefore obligated.
Pause.
Lordship,
It is not in dispute that the plan for construction of the building was sanctioned.
Lordship.
Do you have any sanction?
No, I have
Please
not.
show me.
It's an unauthorized
Then
construction.
how do you,
No, but
how do you apply this judgment?
I am saying that
Here, this person had a sanction.
under what section they are demolishing, what is the detail of my
Notice
property?
may be vague, so we will ask them to listen to you and
They are
decide.
already demolishing, therefore, and I am with the photographs where
So we come to at least this, that this judgment will not help you.
this will help. At least they have to produce what property
they will
they are
give
straight away
Okay,
demolishing.
They will.
But one Vipul Patel I am making statement, there is no notice to him, still his entire infrastructure is already demolished.
Is he before this court?
No, he is not before this court. I am just stating it
Yes.
for putting it on record that when they are coming for demolition, they have to specify what survey number, what area of my property is unauthorized. Even if the entire property is
Now, why
unauthorized,
do
at
we-
least some details.
You
must be.
show me your legal sanction plan.
I am here.
You don't have.
I am
the
stating
judgment
it
is
that
not
it's a construction in the agricultural land. Therefore, it was not. Therefore, we have not gone for sanctioning for the plan. It's a construction which is in my agricultural land, and originally it was inside. Post that, when the road was widened, one more judgment, Lordship.
You are admitting
Please
that
don't-
it is. Yes.
Yes. Lordships may kindly come to page 6, para 10. Lordship, please. Second line, the learned author stated so and so, unless the contrary intention appears, the conferring or by an enactment of a power or duty to make a decision by implication imports related principle and rules of law. These are the principles and rules which have been laid down or adopted by the court to govern the making of such decision in the territory to which enactment extend. The author further states that it follows that the rules apply to every type of functionary upon whom any act confers a decision-making duty that are implicit in the act. The aforesaid observations were adopted by so and so in the so and so judgment. Now, Lordships may see para 12. Fifth line from the bottom. The legislature has not given command to the commissioner that he shall, without notice, cause encroachment to be removed the section has conferred discretion on the commissioner to cause an encroachment to be removed with or without notice. That discretion has to be exercised in reasonable manner so as to comply with the constitutional mandate that the procedure accompanying the performance of a public act must be fair and reasonable. Now, Lordship shall come to page 7, para 14. Lordship, please. Para 14. I may read from the middle of it. Chief officer of the municipality have not recorded the reasons to show that there existed exceptional circumstances which needed departure from the ordinary rule of following the principle of natural justice, that is audi ultram partem. Now, my lords may come to page 8. Here, clear observation that even if there is a trespasser, he cannot be removed straight away on eviction, and straight away demolition can. Lordships may come to para 17. Page 8, para 17. As observed herein, no such circumstances have been shown in existence in this case by producing contemporaneous record. Of course, an attempt is made to justify the action by making certain amendments in the affidavit in reply, but it is an admitted position that before taking action, no reason has been recorded. There is no contemporaneous document indicating that there existed emergency which brooked no delay and situation demanded dispensing with the observations of principles of natural justice. Therefore, on the basis of the government made in the affidavit in reply, the action cannot be justified. So here the Palika is the respondent. If it is permitted, it would mean that the order decision which is initially bad may be good by supplying reasons later on. This is not permissible. Therefore, also the action cannot be justified. The decision of the Honorable Supreme Court in so and so has been followed by in the case of Nehru Marg Cabin Association versus Modasa Nagar Palika and others reported in so and so in para 4 and 5 reported decision. It is entirely observed that even a trespasser should be asked and be given a reasonable opportunity to depart before force is used to expel him. Further, the decision of the Honorable Supreme Court in so and so in Union Territory, it has been referred to that then it is observed that in all cases it will be for the court to decide whether the procedure adopted is reasonable, fair, just or otherwise. But the few lines down, para 19. Para 19, what is observed? Even trespasser cannot be removed without affording an opportunity of being heard and without giving sufficient notice so as to enable them to remove themselves from the place alleged to have been encroached. Lordship, this is a judgment whereby there is no description of the property. They were on a vegetable market and Otla were construction and they were doing business over there. They were also straight away evicted. Therefore, this has came up before my lord. These are the facts of this case, and I am presenting this rise. They have to first produce what survey number they are demolishing, what property it is, what is the detail of that property, and one opportunity before the demolition begins to listen to me or to make a representation stating that why it shouldn't be demolished. This is a disguised notice. It's straight away stating that in 10 days we'll demolish. Now, lordships may come. Lordships, if my lords may permit, there are 3 judgments to that effect that a vague notice cannot be entertained by this honorable court. And now, lordships may permit, they may take Municipality Act. Thereby, it is stated that even if there is a DP line, there is a 1 month provision, that 1 month must be given for the one whose land is being taken. And furthermore, I am submitting that just for the problem of traffic, they are stating that I am in the margin. Even if the margin is there, the traffic will not go in my margin. If I have made a construction in the margin land. Now that margin land is that construction is demolished, but still the margin remains with me. They are stating that I am in the margin land. Now margin land construction is demolished. Okay. Post that, the margin is not taken by the Nagarpalika and they cannot straight away take. They have to make acquisition of that land. Post that, they can take that land and widen the road. Now, lordships, if my lords may permit, I may take to that provision. It is clear. Even otherwise, 185 is also there, whereby at least the objections must be heard first. Even if I am on a public street or on some illegal encroacher, then also I am given the opportunity to raise my objection. Lordships may kindly come. Lordships may take up Municipalities Act. And one more submission, my lords. Section 2, there is no definition of authorized construction. They are saying I am an unauthorized constructor. There is no definition as to what is authorized construction. Lordships may first come to section 185 that will clear the picture. Am I? May I? Lordship, please. Obstruction and encroachment upon public street and open space. Now, before this, I may just say, this is not a public street where I have encroached. This is not a place where I am the illegal encroacher. So they can straight away comment, even if they cannot, I am covered by the judgment. But before I may read this section, there is specific written no private, not a private property. I may just read. Whosoever in the area thereafter it has become a municipal borough shall have built or set up any wall, so and so step or projecting infrastructure or things other encroachment or obstruction shall deposit or cause to be placed or deposit any box so and so merchandise even otherwise in any public place or street or in or over upon any open drainage, gutter, sewage adequate in such place of the street shall be punished with fine which may extend to 50 rupees and with further fine which may extend to 10 rupees per day on which such projection, encroachment, obstruction, deposit continues after the date of first conviction for such offence. Now, Lordship, is very important. The chief official shall have power to remove any such obstruction or encroachment and shall have the like power to remove any unauthorized obstruction or encroachment of the like nature in any open space not being a private property, whether such space is vested in the municipality or not, provided that if the space is vested in the government, the permission of the collector shall have first been obtained. The expense of such removal shall be paid by the person who has caused the said obstruction or encroachment and shall be recoverable in the same manner and as an amount claim on the account of any tax recoverable under chapter so and so. Whosoever not being duly authorized in that behalf removes earth, land, material, any or make any encroachment in or upon any open space which is not a private property shall be punished with fine extend to 200 rupees in case of encroachment, further fine which may extend to 20 rupees on day to day, which encroachment continues thereafter first date of conviction for such offence. Now, this is 185. It states that even if there is an encroachment, then also there is a specific procedure laid down. Now, Lordships may come to 150 because it states that there is a DP line. So, therefore, 150. Lordship, may I read 150? Lordship, please. Regular line of a public street. The chief officer shall, subject to the approval of the municipality, prescribe a line on each side of every public street within the municipal borough and may from time to time prescribe a fresh line in substitution to for any line so prescribed or any part thereof, provided at least 1 month previous to the prescribing such line. Here they have stated on Oreder 4-23, they have made the marking. At least 1 month previous to the prescribing such line or such fresh line as the case may be, the chief officer shall give public notice of proposal and shall put up special notice thereof in the street or part of the street for which such line or fresh line is proposed to be prescribed. The chief officer shall comply with any order passed by the municipality after considering any written objection or suggestion in regard to such proposal delivered at the time of the municipality within such time as may be prescribed in such public or special notice, provided that the width of the street as per line once prescribed shall not be curtailed, or that the line once prescribed shall not be shifted towards the center of the street without the sanction of the collector. Now, Lordships may see it this way. They are stating that I am in margin land. Even if my construction, which is as per their alleged allegation that it is a construction which is in the margin, then the construction of the margin portion, if removed, still the margin land is of mine. That cannot be taken straight away for the extension of the road. And if it is taken, then 1 month is given. Now, Lordships, that is my submission because they are straight away saying they are demolishing. They are straight away on the way that they want to demolish. And Lordships may see the photographs because demolition is already begin. Uh, the notice was served to me on 3rd and on 4th, to one petitioner on 3rd and 3 other petitioner on 4th. I mentioned before the coordinate bench on 5th for circulation. I was stated that I have to go to correct forum. I went to collector as well as to Nagar Palika. Not called, not heard, no notice, no appearance, nothing. I have the received copy. I may show it just now. Post that I have mentioned before. Therefore, I am before my lords. I am stating that it is not that I am here on 10th or 12th. I am here on 22nd. The demolition began on 18th. On 15th, there is a communication to police for protection. On 18th, they begin the demolition. Till now, they already demolished 20, almost 20 infrastructures, which according to their notice itself, they state it is in margin. And there is a parking difficulty, traffic difficulty. Therefore, my margin land is demolished. So there is parking difficulty, traffic difficulty. Then there has to be arrangement with the traffic police, or else there is to be an acquisition procedure. There is a judgment of this honorable which states that even 226 there is a provision, it can be entertained for compensation also. Even I may show the other petitioners, all the petitioners are having house tax and electricity bill from 30-40 years of the said land, which shop number 1 to there is numbering of the house in the shop also. That I may show. So at least one opportunity of hearing must be given to me. Post that there has to be a demolition.
Okay, all 4. The petitioners in the present petition.
Lordship, please. No, this judgment, I may not, these are stating that if there is a vague notice, then it cannot be entertained. Vague notice, because what the notice states that straight away they are demolishing. There has to be a detail. Even if it is not, it has to be considered as a vague notice. So this judgment shows that vague notice, it cannot be taken into consideration in a way that the notice was given. Even if the notice is given, it is to be given in such a way that opportunity of hearing must be given to me.
Okay. By way of this petition, the petitioners have referred the present petitions under Article 226 of the Constitution, seeking to challenge the show cause notice dated 4/5/2023, issued by the respondent number 2 for the illegal construction that the petitioners have constructed on the road. Next paragraph, the petitioners have made the following clear in the petition. A. This honorable court may be pleased to admit and allow the present petition in the interest of justice. B. This honorable court may be pleased to issue a writ of mandamus or any other writ in the nature of mandamus or any other writ, order or direction, quashing and setting aside the show cause notice dated 4/5/2023, issued by the respondent number 2 in the interest of justice. C. During the pendency of the present petition, this honorable court may be pleased to stay the implementation and operation of the show cause notice dated 4/5/2023 and restrain the respondents from taking coercive steps or actions which can prejudice the petitioner in any manner in the interest of justice. D. For ex parte interim and ad interim reliefs in the terms of the prayer C herein above. E. For any other reliefs that this honorable court may, in the facts of the present case, deem fit. Next paragraph. I have heard learned advocate, Mr. H.K. Bhambat for the petitioner at length. The learned advocate has taken this forth through the notice issued by the respondent number 2, dated 4/5/2023, which states that the illegal construction made on the Sulpad Mora Manav Milan Mandir to Hanuman Mandir Road in the margin area in the alignment of the BP road is without any permission, and it is causing obstacle to the vehicles and the traffic. And on 18/4/2023, the marks were made regarding the illegal construction, which have to be removed within 10 days. The learned advocate has relied on civil appeal number 5948 of 2008, arising out of SLP into bracket C number 4599 of 2007 in the case of Municipal Corporation Ludhiana versus Inderjit Singh and another, and 1995 into bracket 1 GLH1 in the case of Dalwadi Laljibai Katurbai and others versus State of Gujarat. The learned advocate has also gone through the provisions of section 150 and section 185 of the Gujarat Municipals Act 1963. The main grievance of the petitioners is that the respondents have not followed due process of law and have not given the opportunity of hearing, and have straightaway issued the notice to demolish the construction within 10 days. The learned advocate has also submitted that the demolition process has already been started, but the learned advocate has admitted that shops and residents. You are residing on the top floor, right?
On the
Down
first
there
floor.
are shops.
And there, not for all 4 petitioners.
Okay.
Lordship, I may just say.
A few petitioners. Okay, some of the petitioners.
Some of the
petitioners
Yes,
have
yes,
constructed shops and are residing on the first floor of the construction, which is for which no permission from any authority has been taken. There is also the grievance that the sufficient time has not been granted as per the provisions of law, and hence considering the above and the documents submitted by the learned advocate for the petitioners, the respondent is directed to give sufficient opportunity of hearing to the petitioners
Lordship.
and to strictly follow the provisions of law
Okay.
and take decisions as per law.
No, but till then, Lordship may just see the photograph. Demolition already begin.
You go there.
No, I have got, Lordship,
Direct
yes,
service.
yes. For a moment, only for a moment. Lordship may permit. So this is the received copy of collector and Nagar Palika. Before the demolition have begun, I have.
You go there immediately.
Yes. I have already made a replacement.
No, I'm directing them to listen. No, they will listen to you and then take action.
But they are demolishing today, even today, the demolition is already
You
cut.
immediately take this order.
No, Lordship, before the demolition begin, I have just, it's a, absolutely, I am following what.
Now this court has passed an order to